and we're now recording. So Professor Moss, take it away, sir.
Thank you. Thank you. As Taylor said, and you should all have your mute buttons on and your video buttons off so that the only time I will see you is when you ask a question through the chat function. Now, let me introduce myself. First of all, let me make sure that you understand that this is the intermediate and advanced section for the meeting, and we're doing the opening statements and closing arguments. So if you're in the wrong room or want to be in another room, now's the time to switch. But let me introduce myself. My name is Fred Moss, M-O-S-S. I'm a retired law professor from SMU, where for 31 years I taught trial advocacy and also coached some of the SMU mock trial teams and also taught criminal law and evidence. So now before I was teaching, I was a prosecutor for 4 years. And so I'm pleased that for our purposes that this is a criminal case that we're going to be dealing with this year. And I'm going to talk about some of the particular aspects of being a criminal case and how it affects your opening and closing statements, because there are certain unique aspects to criminal cases that should be raised and utilized or at least mentioned and discussed with the jury in your opening and closing statements. Now, let's talk first about opening statements. Now, in a real trial, of course, the first time the jury gets to know you is in jury selection, but we don't have that in the competition. So your opening statement is the time when you are going to make your first impression with the judges. And therefore, it's extremely first impressions, as your mother has probably always told you, are very, very important. It can sort of get the people who are watching and listening to you to give them the first impression as to whether or not you are basically prepared, confident, and ready to go. And so think of when you're getting up to do your opening statement, regardless of whether you're the prosecutor or the defense, that as a first impression, you've got to be confident, you have to be assertive, and you have to appear to be prepared. In other words, your comments have to be well organized. Now, I know you've probably written them all out, but it's always impressive for the judges if you do not read your opening statement or closing statement, as a matter of fact, that it's okay to have an outline there. And I always suggest, just as a sort of a safety blanket, that you have an outline of what you want to say written nice and large and in front of you, so that you can just glance down and make sure that if you have a mind glitch, a little that you can look down and remember where you're going and where you've been. So tell us, but overall, for the purposes of both opening and closing statements, think about the fact that human beings love stories. We live stories. We live for stories. We go to movies. We read books. We watch television. We tell one another about what we did on our vacation, and they're stories. We love stories. And so all the experienced trial lawyers will tell you that jurors love stories too. And basically what they are doing is sitting there and they're going to hear two stories. One, the prosecutor's story as to what happened and why the defendant did what he did, as they claim. And then the defendant's story as to why what happened was entirely different than what the prosecution is claiming. So think of your case as a story that you're competing with for the other side to adopt your story as opposed to their story. But think in terms of stories. Now, your goals in opening statement, regardless of which side you're on, is to help the jury understand the nature of the case. In other words, what charges have been preferred against this defendant? What is he charged with doing? That's the prosecution's goal. And and also how are you going to prove this? You're going to call witnesses who are going to prove and then tell your story that on a certain date this happened. And the defendant did this, and the defendant had these motives, and the defendant had this opportunity, blah, blah, blah. So you're going to be telling that story. You don't have to get down into the weeds and say, you know, on 1:30 p.m. on the 22nd of June in 2019, the defendant's the name, blah, 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 did this witness, so-and-so. Don't get into the weeds. This is the overview. This is the overview of the case, and you just bog it down if you get too deep into the weeds, both sides. Now, you're also going to have to probably talk about the law, because the law is what decides what facts are relevant. And so if it's a case like, you know, a theft case, you're going to say, we're going to prove the defendant did take without permission property belonging to the victim, you know, something like that. So that's the law, and that's you're going to talk about. So you're going to make the jury understand what the overall charges are. Who are the parties? Who are the characters in this little story? And what you're going to be asking the jury to decide. And and in fact, your goal is to not only just simply familiarize themselves with the charges and who's involved and why, but also you're going to be trying to persuade them. Now, you can't argue, technically, you can't argue in opening statement. This is an overview of what you claim the evidence will show. But any good lawyer will tell you that actually the way you state your case is, in fact, a form of argument. And that will be noted by the judges that you have stated a very strong case and very affirmatively, and that therefore probably impresses the jury that, wow, this looks like they have a good case. If they have decided at the close of the opening statement, either side, that say, wow, you've got a good case, then you have partially persuaded that jury that your story is the correct story. Now, at the beginning, especially the prosecutor who goes first, I think you should try for a little bit of a dramatic opening. Ladies and gentlemen of the jury, this is a murder case. Why not? Grab them. That's the first chore, is to get their attention, then keep their attention and persuade. So a lot of times, and what seems to be standard operating procedure these days, is to sort of do the prefatory grab and then introduce yourselves. Well, that's fine. I don't have any problem with that. I like the grab, but you could introduce yourself and your cohorts there at the end of your opening, as well as at the beginning, or even in the middle. Who cares? But be affirmative, be dramatic. We will prove beyond a reasonable doubt that the defendant killed the victim, you know, okay. And use victim, use the name, don't use victim. I'm just using victim here in a generic way. Depersonalize the defendant. Don't refer to them necessarily by his name, certainly not his first name. He's the defendant, and you're pointing at him in the courtroom, right? The defendant. So, and defense attorneys, don't depersonalize your own client. Don't refer to your client as the client or as the defendant. He's John Jones. Refer to him as John or Mr. Jones if he's older man. Okay, so don't depersonalize your own client. But after you've introduced yourself and all of that stuff, what a lot of prosecutors will do will say, you know, I'm John Jones, Deputy District Attorney, and I am proud to represent the people of Texoma. I'm here and I am proud, you know, so express the fact that you are not a hired gun, You are a representative of the state of Texoma or the people of Texoma. So use that, wrap yourself in the flag, so to speak. Now you tell yourself, okay, now they know who you are, what the case is about, the charges are, and then you basically tell your story through, we will call witnesses who will testify to the following things. Again, you can keep it at that general level. And as long as you sprinkle into your opening statement, and this is for both sides, to avoid being accused of arguing, you sprinkle in little phrases like, the evidence will show, the witnesses will testify that, we will have a witness who will say that, you will learn. Those things tend to cut off any arguments, any objections that you're arguing, although usually objections are not made during opening statements. But certainly the judges will hear that and know that you know the art of persuading without arguing. But as I said, keep it simple, because your job now is to simplify matters for the jury and to give them a clear, simple view of your story. Now, everybody in the courtroom, both sides, their case should have a theme or a theory. And here's where you got to introduce your theme or your theory of your case to the jury, which then will be carried through all the examination and to the final exam, to the final exam, so I'm a professor, to the closing argument. So your theme or your theory, you've got to pick in advance, and everybody's got to be on board with it. Now, what kind of theme or theory could you have with regards to the prosecutor? You could say this is a case about jealousy, or this is a case about greed. This is a case about revenge. This is a case about, so every party in this case should be able to frame the theme of their case in one sentence. And then that should pervade the rest of what you do and your purpose in asking questions and your final argument. So find a theme. And for the defense side, it may be, this is a case of a bungled investigation. This is a case of my client being framed by somebody who hates them. This is a case of a rush to judgment. This is a case of a tragic mistake in identification or something like that. So you've got this one sentence theme, which is going to be what you're going to ride in the courtroom with and ride all the way through the case to the final summation. Now, for the prosecutor, let's assume that you've got a case where there's just a lot of, no direct evidence of somebody saw him do it, the defendant do what it is. So it's a circumstantial evidence case. Now, you got to admit your weaknesses in opening statement. You got to say, now, we're not going to call somebody who's going to say he did it, but the amount of circumstantial evidence will overwhelmingly show that the defendant did it. So you're embracing your weaknesses, and you're basically going to point out that there are just too many coincidences here for there to be any other conclusion than that the defendant did it, that there could be no reasonable doubt. Now, find a homey example of how strong circumstantial evidence can be, and argue that circumstantial evidence can be just as strong as direct evidence. The homey one that I often heard used in Texas is that if you're walking down a road and you see a turtle on the top of a fence post, well, somebody put it there, even though you didn't see somebody put it there. But that's circumstantial evidence that there was somebody else there who put the turtle on the fence post. Robinson Crusoe, for those of you who remember that old one, where he wakes up and he sees a footprint on what he thought was the island, where he thought he was alone on this tropical island where he was shipwrecked, but he spots another person's footprint. Didn't see the person, but we now know there's another person on that island. That's circumstantial evidence, and it is compelling. And so you can make the argument that your case, even though circumstantial, can be compelling and will be compelling to the conclusion that the defendant did it. So the prosecution at the end, we're going to be saying, like, thank you, and we are confident that after hearing all the evidence, you will find the defendant guilty of fill in the blank, murder, robbery, whatever it is, okay? So tell them what you want them to find and sit down. And now, defendant's opening. Defendant's opening, of course, is to sort of take the air out of the prosecutor's balloon that they just blew up in front of the jury. A lot of lawyers, defense attorneys will at this point out the fact that, remember, what you just heard was not evidence. It was an argument. It was what they hoped to prove. And that, as my mom always said, there's always two sides to every flapjack, right? There's two sides to every coin. And they who have only heard one half of the story. You do not decide until you've heard both sides of the story, because only after we have put on our case will you know all of the facts, and that for which you decide. So you ask them to withhold their judgment, wait, be fair, and it's only fair that you be able to hear both sides of the argument before you decide. And so you rely on that sort of sense of that's the right thing to do.
Now, Fred, let me jump in. We've got a question in chat. Okay. And the question is, I've seen some teams use metaphors or analogies as themes. Is that recommended? Yeah,
I think that's a good idea. If you can analogize your story to something that everybody's familiar with and leads to the right direction that you want them to go, then I think that's right. In fact, old-time lawyers used to use Bible stories to show their theme. But you could use well-known TV shows, movies, books, whatever, or just homey sayings that you learn around your house that everybody knows. You lie down with dogs, you might come up with fleas, something like that. That might be the theme of your story, that's what the defendant did. But in any event, I think using those things is always impressive to the judges if they're really pertinent. They're very right on point. Sometimes I've seen people come up with analogies or things like that are just simply, you just can't see how they fit. So make sure they're good. And I should point out the fact that I've been judging these high school mock trial competitions for, I don't know, over 10 years, I guess. And so I've seen people do that well, and sometimes sort of where they misfire. It just doesn't seem to work. So just because it's clever in itself doesn't necessarily mean that it fits the facts of this case. Now back to the great
commonality too. Try to avoid sports analogies. For example, if you use a baseball analogy, the jury's not a baseball fan, it's going to fall flat. Pop culture, just be careful, make sure it's really relevant and everybody on the jury is going to get it.
Yeah, I mean, there were always situations where people would make football analogies or some sport where women were not necessarily involved, and they run the risk of the women or the people who don't play that sport or are unfamiliar with that sport not understanding how it works. So in any event, but you want to humanize your client. Now, one of the things I always say is that, AT&T used to have a little advertisement where you reach out and touch someone with long distance, right? Well, defense attorneys, you can't do it here, but you want to humanize your client. If we could see it in court, you want to go over and touch your client on the shoulder and say, I'm proud to represent Mr. John Jones, the defendant in this case. But the way you can do it still in terms of humanizing your client is, again, as I said, not refer to him as the client or the defendant. It's your user's name. Now, as for the fact that this is a criminal case, so there's certain aspects of criminal cases that the defense attorneys can use in their opening and closing statements that you can in civil cases. For example, the Constitution says that the defendant cannot be forced to testify against himself. In other words, the prosecutor can't put on the defendant. And that also, if he fails to testify, there's a presumption of innocence. He can't be used against him, the fact that he didn't testify. Well, in our cases, it's just stipulated that the defendant has decided to testify. And therefore, the defendant will testify. Well, this gives the defendant an opportunity to say, even though he is constitutionally protected and given the right not to testify and have it used against him, in this case, Mr. Jones will take the stand and deny these charges and tell you what really happened. Okay, so use that. That's not unfair, because we have just decided that he has decided to testify, and you can use the fact that he's decided to testify in your favor. Also, criminal cases, the burden of proof is much higher than in civil cases. It's beyond a reasonable doubt. That is, all reasonable doubt has to be eliminated by the other side. The defense attorney should always use this in opening statement, closing statements, to remind the jury that they don't have to prove anything. It's the prosecutor whose job it is to prove beyond all reasonable doubt. They have to eliminate any doubt that is based on, which is reasonable, based on reason. And it is the highest burden of proof in our legal system. It's higher than preponderance of the evidence in civil cases. It's higher than clear and convincing evidence used in, say, paternity cases, taking babies away from their parents. It's the highest. It's beyond all reasonable doubt. So that's a given, and the defense have got to make use of that as you possibly in their case, both in the opening, I suggest, and certainly in the closing. Now, you've got to introduce your theme too. In other words, what is this case about? Rush to justice, innocent man charged, framed by people who don't like him, a bungled investigation, whatever you want. Now, again, be general. We're going to listen to our cross-examination of prosecution witness, listen to our witnesses, and they will show that this is what happened, blah, 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 blah. Okay. And again, sprinkle in, you will learn, witnesses will testify, you will hear, things like that, in order to not be arguing. But at the end, again, remind them, wait to decide. Wait to decide. It is till they hear both sides of the story, then thank them and sit down. But also, as I said, make sure they know that you're there confident, and you feel that you're privileged to represent this innocent man who's been falsely charged. No personal opinions, no I thinks. Okay, can't do that. The language you should use, of course, I don't think there's much problem, because you haven't gone to law school and learned how to speak in this strange language we speak in, legalese. But talk to these jurors at a level of, if you were explaining this case to your grandmother or your sibling, right? That's the level it ought to be at. And no monotone, right? If you read, you're going to be doing it monotone. But even if you're not reading, don't use your voice. Slow down, higher, lower, use it as a musical instrument. Musical instruments don't come across the page like that on the staff, right? Up and down, pauses, slow, and slow down. One of the biggest problems we see with students, because they're under such strict time limits, is that they go 100 miles an hour and it all gets lost in one big blur. You got to be able to do it within the time limits, but at a speed that the listener can absorb. It's not a question of just getting from start to finish as fast as you can. It's to do it in a way that is persuasive and impressive.
So Fred, we got one more question here, and I think you've covered it right now. But the question is, I believe body language is a big part of presentation. With competition being virtual, what advice would you give to help make a good first impression without the in-person connection?
Yeah, that is a great question, and it's one that we have pondered in putting this competition together. I actually asked that question yesterday of the vice chair about whether or not during opening and closing you could actually stand and do it. I think if you can, then you might want to try, but the problem is that you might be back so far from the microphone that we can't hear you. But that would give you an opportunity to use a little bit of body language, use your hands and all of that stuff. But even as we're on, if you're seated, you could still possibly use your hands occasionally to emphasize something. Yeah, blah, like that, or number one, number two, number three. So you might be restricted to just your face and your hands. Don't do too much stuff. Obviously, this would be distracting. But it puts the emphasis on the need to use your voice as your sort of body language. And that is to, slow down when it comes to things that are really important. That's the way we just sometimes talk. Modulate, up, down. So I think it puts the emphasis on the need to use your voice and your face and a little bit of your hands. And unfortunately, those of you who are really good at body language otherwise are going to be somewhat handicapped. But you might try if you could stand with your practice, because I don't think there's any prohibition on you doing your opening and closing from standing. It's just a question of whether it will work, and we'll be able to hear you. Okay, any other questions on opening statements? No? Okay.
We'll give it a second, let them, if any students have any other questions, give them a minute to type it just to make sure. We'll hold.
Let's see, we go to 10:55, so I got about, 15 minutes?
Roughly, yes, sir.
Okay. Don't see any pop up.
You've done an amazingly good job because there are no questions.
Right.
So everybody who's in this room right now is going to win.
Well, these people are experienced. I assume that all of them have actually been on the firing line and have experience, and can hopefully this will reinforce what they've been taught. I'm sure I'm not teaching them anything new that they can't get from their coaches or didn't do last year. But let's talk about closings in the criminal case. And because it's a criminal case, by the way, both sides have got to be pretty deadly serious, because I think you've got, for next year, you've got a murder case, and that's the most serious criminal case you can have. And so people have got to adopt a sort of a very serious demeanor. But the closing argument, other than maybe cross-examination of the opposing party, is probably one of the most dramatic high points of the trial. This is where both sides are sort of bringing together what they've brought out and asking the jury directly to infer and to come to the conclusions that you want them to come to on the basis of the evidence. And so you could be dramatic. Some people like to start the closing argument with a little excerpt from the trial. So if you have a witness that has said something which is very, very telling, extremely telling, and works in your behalf, I don't care if it came from your witnesses or their witnesses, but whoever did, or you have a piece of real evidence, the gun, the bloody shirt, the knife, whatever you might have, you might start with that. So it would be, ladies and gentlemen of the jury, on that stand, John Jones admitted blah, 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 or John Jones heard the defendant say blah, 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 something very incriminating, whatever. So that would be what the prosecution would try to do with a sort of the initial grabbing the attention of the jury as the opening of the closing statement. The defendant can do the same thing. But, so strive to be a little bit dramatic. Now, as I said, don't read. There's no way you can be dramatic. There's no way you can probably avoid talking too fast or in a monotone voice if you're reading, both for opening closings, and I think this is true also for direct and cross-examinations. Just have an outline at most as your safety blanket, written large, just bullet points. So you know exactly where you want to go and when. Hopefully you don't need it, but it's there just in case, and gives you a little feeling of security, and that security feeling might make you better. But, many centuries ago, Cicero said that the speaker who is trying to persuade has to be clear, to be understood, has to be interesting in order to keep them listening, and persuasive so that they will agree. So clear, interesting, and persuasive. Now, clarity is important. And clarity here is really based on your organization of your themes and your theories and your facts. And the closing argument is, as I would tell people who were talking about how to set up, how to get ready for a mock trial, the closing argument is the blueprint of the entire case. And in fact, what you ought to do before you even write your directs, your crosses, and your openings is you write your closing statement. Write your closing statement in order to be able to gather together all of the stuff that you want that you marshal together to prove your case. And then everything else is directed to getting the information that goes into the closing argument, because this is the whole story from your point of view. Now, again, in general, no personal opinions. I think that so-and-so was totally believable, blah, blah, blah. No personal opinions are allowed in argument. Also, you have to be flexible. I'll tell you what really impresses judges who are watching this and voting is that your flexibility. That is that when you have written out your closing argument and you expected that a certain piece of evidence was going to get in and it didn't come in, the witness forgot to say it, or you forgot to ask the question, and that evidence didn't get in, excise it from your closing statement. Because we as judges will hear you say, and you heard so-and-so say such and such, blah, 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 and we're sitting there. No, he didn't. Why are you saying that? He didn't say that. Shows a lack of flexibility. But on the opposite side of that, in terms of flexibility, is when something has happened at the trial that you didn't anticipate that really helps. Some witness on their side says something that's just golden for you. Put it in your closing statement, even though it wasn't there earlier. So that means you're going to have to, during trial, keep a little bit of a list of things to add or things to subtract. Now that requires a lot of flexibility and confidence and organization. But believe me, when we see people do that, the judges, then we're impressed that you had that ability to do that. Now, when you close, obviously you thank the jury for their attention. You could do that at the beginning, you could do that at the end. Don't care. Just make sure you thank the jury. If you don't, probably not going to get you. Accept your burden. If the prosecution, accept the burden of proof beyond a reasonable doubt. We fully accept that, and we have met it. And let me tell you how we met it. We brought in this, we show this, right? So don't minimize it. And but you can explain that beyond a reasonable doubt doesn't mean eliminating all doubt. Read the jury instructions. It's right there. It's defined for you. And you can say, if it required all doubt, then nobody would ever be convicted. Because somebody would come up with some cockamamie idea about how he could have not done it. But that's not the standard. You have to have, if a reasonable doubt is a doubt based on a reason. In other words, one of those doubts that you would, reasonable doubts that would cause you to pause in doing something important in your life, like buying a car or a house or something like that.
So on point, Fred, there's a new question.
Yeah.
In regard to closing in the defense opening, would you recommend incorporating the other team's theme?
No, you've got your theme. You can pour water on the other team's theme as your theme. In other words, like they say that this is a terrible investigation, but here's what was done. It was a good investigation, and here's, or no, that would be the prosecutor. If the defense attorney was saying, okay, that this was a mistaken identification case. Well, here's all the evidence that shows that it was a mistaken identification. So I don't think you want to do that. I think you want to have your own theme and drive it home. Ride your own horse. Don't try to defend against the other side's attack.
And in closing, the prosecutor is going to reserve some rebuttal time. So they might be able to end on blowing up your attempt to preempt their theme and then reinforce their theme and then rest.
Yeah.
Counterpunch.
As some coach, I'm sure, basically said to his team that the best offense is a good offense. Go for it. You know, sometimes you got to just slide past their good arguments and make your good arguments. You don't have to have an answer for all of their arguments. That's not going to work. So use the jury instruction with regards to minimizing reasonable doubt. Now, state your positive proof. Here's where you pull it all together. The jury had to hear it come out bits and pieces from the witnesses and from looking at exhibits scattered throughout the trial. This is where you pull it together. Here's where organization is critical. So in a circumstantial evidence case, you're going to say, here is circumstance number 1, circumstance number 2, circumstance number 3, coincidence number 4, coincidence number 5, coincidence number 6. Really? That's sort of your tone. It couldn't possibly be anybody else, the defendant, when you put together all of these circumstances. So state your proof. You can characterize the other side's proof as, grasping at straws. The prosecutor basically has, and especially in a murder case, should show 3 things: motive, opportunity, and means. The motive to kill, the opportunity in the right place at the right time to do it, and had the means to do it, had the weapons or whatever it needed to do to kill. So motive, opportunity, and means. That's your sort of structure of your closing in terms of how your evidence is marshaled together. Let me prove the motive. Let me prove the opportunity. Let me prove the means. With all this evidence, it points only in one direction and one direction reasonably, and that is to the defendant. So, so tell the jury that you've kept your promises that you made in an opening statement by proving beyond a reasonable doubt the defendant did it. You thank them and express confidence in their verdict when they come back. Now, the defense, of course, will be simply debunking the prosecution's case and will be pointing out their strong points, marshaling their strong points, which cut against motive, opportunity, and means. And hopefully you've got a, quote, plan B, which you can point to somebody else who may have done it. And if the facts of your case are such that there are other possible culprits here, here's where you want to show that there is reasonable doubt that your guy did it, and because there is a reason to believe that somebody else did it. So that might be your theme and what you're going to do in your closing for the defense. But again, rely heavily on the burden of proof, beyond a reasonable doubt, highest in our system of justice, and that they have failed to prove all of that they must prove. Now, in some cases, there's not a lot to prove. Did the defendant do X at this time to this person at this time? That's it. But there may be a lot of elements, of it. So for example, in that that example that you were given, sample case. Let me find it here. There are several elements to it. That's the Texoma versus Stellar. They had to intentionally cause danger to the public by putting them in fear of their lives, by igniting a fire in a public place. And so they have like 4 or 5 elements that they got to prove. each one they have to prove beyond a reasonable doubt. So if it wasn't intentional, in other words, it was accidental, maybe even reckless or negligent, that's not good enough. They have to prove beyond a reasonable doubt intention, that purpose to do that. So there may, in other words, the defense may argue that, well, they may have established this and this, but they have failed to prove this element and this element. And you want to focus right on those. Don't talk about what they proved. Talk about what they failed to prove. And that under the law, when they have failed to prove beyond a reasonable doubt all the elements of the crime, the jury must acquit. It's not a may acquit. It's must acquit. So end with the burden of proof on the prosecutor. You don't have to prove anything, but you have shown that it wasn't the defendant. Okay. I think we're just about out of time now. And any questions at this point? No? Okay.
I'm pending in chat right now.
I think at this point, we go back to the main room, and then everybody by 11:15, everybody should check into the next session of the intermediate and advanced, be it introducing objecting evidence, which I'll do, or rules of evidence, Taylor will do, or witnesses, Jeff Amsel will do. So you get to choose, but again, all of them are being recorded so that you can see the ones that you don't attend in person, or virtually, I should say. But closing arguments are the final impression, and the ones that the judges go off into the voting room with fresh in their mind, and therefore it's got to be good. It has to be organized. It has to be consistent with what will happen in the courtroom, and confident, assertive, and persuasive, even dramatic. Okay, so that's what you want to do. You want to send those judges off into the judging room with a wow factor. You know, when we go back to judge, when that's the last thing we've seen, and boy, if you're really done a terrific job of pulling it all together and making a very strong, assertive, confident argument, you're in good stead. And it might cover up a few other flaws that might have happened during the trial. Okay.
All right. Well, with no questions being on the chat screen, I'm going to stop recording and ask everybody to go back to the main room. Thanks very much for stopping by. You're welcome, Eric. Have a few thank yous. Thank you guys very much. And we're going to stop recording in 3, 2, 1.